Can mercenaries qualify as prisoners of war under international law? Recent developments in international conflicts have raised questions about the status of mercenaries. A hot topic right now is whether these individuals can be classified as prisoners of war under international law. With ongoing military operations and the use of private military contractors, many are searching for clarity on this issue. The status of mercenaries is governed by the Geneva Conventions and the laws of armed conflict. The Third Geneva Convention outlines who qualifies as a prisoner of war. This includes members of the armed forces of a party to the conflict, as well as militias and volunteer corps. However, there are specific criteria that must be met. To qualify as a prisoner of war, individuals must be commanded by a person responsible for their subordinates. They must also have a fixed distinctive sign that is recognizable at a distance, carry arms openly, and conduct operations according to the laws and customs of war. Mercenaries, who are often private individuals hired for military service, usually do not meet these criteria. Because they often lack a fixed distinctive sign and do not operate under a responsible command structure, mercenaries are typically not recognized as prisoners of war. International humanitarian law does not specifically address the status of mercenaries. If they do not meet the criteria for prisoner of war status, they are considered unlawful combatants. Unlawful combatants do not receive the same protections as legitimate combatants. This means they may not be entitled to the rights and protections that come with being classified as a prisoner of war upon capture. Instead, they can be interrogated, tried, and imprisoned under the domestic law of the capturing state. However, they must still be treated humanely and granted a fair trial. The use of private security contractors in modern conflicts has blurred the lines between state and non-state actors. This complicates the application of international law. There is ongoing debate about how to classify and treat these individuals. They often operate similarly to state forces but lack the formal status of combatants. In summary, mercenaries generally do not qualify as prisoners of or under international law due to their failure to meet the necessary criteria. They still retain certain protections, including humane treatment and a fair trial if captured during a conflict. As discussions continue, the legal landscape surrounding mercenaries remains an important topic for those interested in international humanitarian law.